We are unmuted. Okay, thank you.
All right, Mr. Manning, who do you have with you?
Judge, I have Miss Chelsea Caver.
All right, this is cause number CR 16633, State versus Chelsea Lee Caver. Set on motion to revoke. Go ahead, Mr. Manning.
Yes, Judge, I received an offer on Miss Caver yesterday. I discussed that with my client today and had the paperwork to go over it. However, one issue came up as we were going over the paperwork that caused a little bit of concern, and we were unable to verify with the state over the lunch break if that issue is dispositive or not. My understanding was that on the original judgment, it was signed by Judge Winters, and my client has informed me she believes that was because there was a voluntary recusal done. We were unable to track down the paperwork, verifying one way or the other than the fact that the judgment was signed by Judge Winters. And so I asked just be given an opportunity to review the record, discuss that with my client, and have a reset, maybe a short reset, so we could figure that out.
Judge, I reviewed the clerk's record.
Here, come up here because he won't be able to hear you from there.
Judge, I reviewed the clerk's records. It does, Mr. Manning is correct. Judge Winters did sign the original judgment, although I can't find any reason why that was. I don't know if it was the bench sharing agreement that the county court of law and the district court had at that time, but I can't find any paperwork that this court has recused itself. This court did, after the original judgment was signed, signed an amendment and signed a motion withdrawing the state's motion to adjudicate or revoke. There's a previous motion to adjudicate or revoke. I don't recall off the top of my head which one, that this court has signed in the interim. So I don't see any inferences that this court has recused or should recuse, but I would leave that to Mr. Manning if there's some freestanding reason at this point to recuse. I just don't see it in the clerk's record.
And Judge, my understanding from my client was that based on the age of the case, she believed that the currently sitting 294th Judge Martin was the prosecutor handling her case initially. And so that's why she believed that the initial case was transferred down to Judge Winters' court. Like I said, I haven't been able to verify that over the lunch break, and I'm relying on the state's review of the record on what I'm offering at this point. So I just asked for a little bit of time so we could figure that out.
I think we would be unopposed to that, Judge.
Okay, give me just a moment. Let me consult the clerk's record and maybe I can figure it out too. Just a moment. I see that that I signed the motion to revoke on August 21st or August 12th of 21.
You signed everything but the original judgment. there's no paperwork indicating why Judge Winters would have.
I'm assuming. Sure.
There's no motion to transfer, no order assigning, so.
All right, it appears to me that Miss Caver had another indicted case, CR 17233, which was a PCS less than one that pled out in the county court of law on April 17th of 2019. I looked at April 17th. That's a Wednesday. This court doesn't conduct criminal court on Wednesday, so it appears that it may have been that Judge Winters signed, that this case was taken into consideration or signed at the same time as he adjudicated her CR 17223 case. How that was put in the county court of law.
And Judge, does it show the disposition of those two cases? Are they both currently pending, or is it, my understanding is just the CR 16633 is the one that was pending.
Correct, yes. But what I'm saying is that Ms. Caver had another case, another possession case, CR 17223, that was in Judge Winters' court. It pled out in Judge Winters' court, and the date of judgment on this case mirrors the date of judgment in the other case.
Okay.
So I'm trying to see if perhaps the felony case in the 294th was resolved with her felony case in the county court of law to explain why Judge Winters was on that. That was a felony case that was also indicted in 2017. So, all right, well, what we'll do is we'll reset to the next docket, September 29th. And we'll take more time to try to figure that out, but we need to get that resolved. And if we find out that I am recused, or we need to figure that issue out before the 29th, so that.
Elaborate on the record. I've reviewed the DA's electronic file. Your name does not appear anywhere in the file. However, Mr. Manning's does appear as the prosecutor record. So we may have a different issue on our hands. Mr. Manning and I will get together and decide that before the 29th, but I just wanted for the record, we do not have notations anywhere in the file that you handled this CR 16 case of Ms. Cavers.
Okay, did you hear that, Mr. Manning?
Bits and pieces, Judge. I'll follow up with Ms. Heisel when I get over there to the courthouse.
Okay. All right, Ms. Caver, I'm going to reset you to September 29th, and we'll try to figure out where best and who best to preside and where to preside over your motion to revoke. We'll try to have that resolved and go forward on the 29th.
Yes, sir.
Yeah, it looks like both of these cases appeared on the county court of law docket. As early as, yeah, it's March 18th of 2019. Yeah, very possible. Thank you, ma'am.
That's gonna change the terms.
The only thing that will change is session.
Is the length is different?
No.
Is the length?
Yes. It's
All right, Mr. Manning, who do you have now?
Judge, Judge, I apologize. There was one concern with the paperwork for Mr. Couch. We were just trying to straighten that out with probation.
Okay.
We are going to be proceeding on an amendment, a motion to withdraw and continue. And the issue that we're looking at is Mr. Couch is currently under medication and would need to go to special needs safety. So we're getting the the amendment to the conditions of probation modified so that he can sign those. Would you like for me to call someone else up, or you want to wait for us to get that corrected?
So it's going to be a withdraw amend with special needs safety, ACOP.
That's correct. And there's also a 1245 of an unfiled misdemeanor case.
Okay, did I hear you right? You say you're getting that paperwork together?
I've been told we're good to go.
All right, Mr. Couch, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you lower your hand. Make sure you speak out loudly and clearly for me. Your name is Joseph Brian Couch, is that correct?
Yes, sir.
And Mr. Couch, the state of Texas has filed a motion to revoke your community supervision. And you've heard Mr. Manning announce that the agreement between you and the state is that the state will withdraw their motion and they will be willing to amend your community supervision to include you going to a inpatient rehab run by the state of Texas known as SafeP. Is that your understanding?
Yes, sir.
And also a part of that agreement, they may be disposing of some misdemeanor, a misdemeanor case or cases. Is that correct?
Yes, sir.
And that's what you're asking the court to approve today?
Yes, sir.
And can you tell me in your own words why I should approve that?
I mean, I'm looking to get help. I mean, I'm tired of living the way I've been living.
Tell me what you're tired of and what you're wanting help with.
My drug abuse problem.
Okay. And what drug do you use and abuse?
Meth
Okay. And how long have you done that?
for 8 years.
8 years? And you understand that I only want to send people down to rehab if they really want to get help. I don't want someone to go down there because they think it's a way to avoid prison. You understand that?
Yes, sir.
So if you go down there and you don't have the right attitude and you get kicked out because you're not really down there for the right reason, you know, that's just going to aggravate me and make your situation worse.
Understood.
And so you're telling me today that you will go down there with the purest of intentions to get help with your drug addiction and try to be compliant with your community supervision conditions. Is that right?
Yes, sir.
Are you pleased with Mr. Manning and the work that he's done for you?
Yes, sir.
Okay. All right. And state you are moving to withdraw your motion to revoke at this time.
Yes, Your Honor, that's right.
And Mr. Couch, you understand that the amendment will also include that you'll have additional fees to reimburse Van Zandt County for Mr. Manning's fees that he's being paid on your behalf from the county. You understand that?
Yes, sir.
And you agree to all those things.
Yes, sir.
All right.
Judge, I apologize. If I may, as part of what led us to this agreement and as part of Mr. Couch's sign of good faith, he got caught up on his probation fees and his monetary delinquency, so that when he comes out from safety, he'll be starting on level ground. He did that prior to us coming before the court today.
Good. Thank you, Mr. Manning. I appreciate that. I'm glad to hear that, Mr. Couch. That's going to help you. It's going to help when you come out on level ground versus having to come uphill. Okay. All right. Court will grant the state's motion to withdraw the motion to revoke. Court will amend the conditions of community supervision to require Mr. Couch to attend the substance abuse felony punishment facility special needs. Court will also amend his community supervision conditions to also include the amendment to the additional attorney fees for indigent defense representation and any aftercare that's required of safety. So once I get that paperwork, I'll get that signed. And do we know how long special needs safety is, Officer Mature? Roughly ballpark? A month. So Mr. Couch, it could be an additional 30 days before Safe P is ready for you, before they have a bed available and are ready to take you into the program. You understand that? So there may be some wait time between here and there. Okay. And so listen, your behavior from now until you go to Safe P, people are going to be watching that. And if there's problems with you out at the jail, then this court may change its mind on whether or not you go to Safe P. You understand?
Yes, sir.
Okay. All right. Then I'm not going to tell you good luck. I'm going to tell you get to work. Okay. All right.
Judge, ready on Mr. Moore.
Terrace Moore, CR 18407. And Mr. Moore is set on motion to revoke.
Yes, Judge, we have an agreement.
Okay. And if someone can outline that for me.
Certainly, Judge. Mr. Moore was on probation for a third-degree felony of possession of controlled substance, penalty group 1 to 4 grams. He was placed on probation in February 13th of 2020 and put on for 5 years, probated for 5 years, and a $2,000 fine. The state has agreed to, upon a plea of true, assess punishment at 3 years confinement and the balance of financial obligations.
And what kind of credit time does Mr. Moore have towards his sentence?
Mr. Moore has 244 days.
All right, Mr. Moore, sir, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
All right, you can lower your hand. Just speak up loudly and clearly for me, Mr. Moore. Your name is Terrace Moore, correct?
Yes, sir.
And Mr. Moore, you appeared before the court on February 13th of 2020. You pled guilty to the third-degree felony charge of possession of controlled substance in penalty group 1 between 1 grams and 4 grams. The court heard the evidence that day. However, the court followed a plea agreement in your case. The court assessed your punishment at 5 years in prison, suspended that sentence, and placed you on 5 years community supervision and ordered you to pay fines, fees, and court costs. It's been during the period of your community supervision that the state has filed its motion to revoke your community supervision. And in that motion, the state has alleged how many counts? State, do you have that up? I don't have any of this paperwork. Mr. Manning, do you know how many counts are in that motion? Do you have that
Yes,
motion?
Judge, I believe there are 7 counts.
7?
That's correct, Judge.
So Mr. Moore, have you reviewed that motion with Mr. Manning?
Yes, I have.
Do you feel like you've had enough time to talk with him about what's contained in that motion and understanding all your rights and your options?
Yes, sir.
And are you pleased with Mr. Manning as your lawyer?
Absolutely.
Okay. And Mr. Manning, you believe Mr. Moore to be competent to enter into this plea agreement today?
He is, Judge.
And does your client waive the formal reading of the state's motion to revoke?
We do, Judge.
All right. So Mr. Moore, at this time, I'm going to ask you in the state's motion to revoke as to those 7 counts or those counts true or not true?
Yes, they are true.
All 7 are true?
Yes,
And Mr. Moore, are you telling me that each one of those is true because in fact, what they have alleged occurred is in fact true? You're not just saying that to get a certain plea agreement?
They are true, Your Honor, but I did have some classes that I had printed, but I had failed to submit those classes. So they're on my email, and I had failed to submit the class. But as far as the courts, no, they are true.
Okay. All right, and Mr. Moore, has anyone threatened you, forced you, made you feel like you had to plead true to any of these counts?
Not at all.
Okay, good. All right, the court will accept Mr. Moore's plea of true to each count. Mr. Manning, any objection to the admission of the defendant's waiver of the rights of plea of true?
No objection, Judge.
All right, that's admitted in evidence, and the court does take judicial notice of Mr. Moore's judicial confession. Anything further from the state?
No, Your Honor.
Anything further from the defense, Mr. Manning?
No, Judge, we rest on those.
All right, court will find that based on Mr. Moore's plea of true to each count and the evidence before the court, that Mr. Moore has violated the terms and conditions of his community supervision. Court will follow the plea agreement in this case. The court, upon finding true to each count, hereby revokes community supervision, assesses punishment at 3 years confinement in the Texas Department of Criminal Justice. Court orders Mr. Moore to pay the balance of his financial obligations, and the court awards Mr. Moore 244 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Moore, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over with Deputy McLeish to be fingerprinted. Good luck to you, sir.
Thank you.
You're welcome. Who do you like next, Mr. Manning?
Judge, if we can call Mr. Canon Racco.
Cannon, Racco, CR 2189, CR 2190. Mr. Racco is set. It just says contested hearing. I don't know if this is a motion or suppression.
Judge, there is a motion. However, I believe, yes, as of yesterday, received an offer to resolve both of Mr. Racco's cases. I haven't had a chance to convey that offer to him as it was received late yesterday, and I've been in court all day today. However, I would like an opportunity to discuss that with him. I think it will resolve his cases here and put him back on a path to hopefully successfully complete probation.
Is the offer to continue him on community supervision?
Yes, Judge, with the addition of safety as a condition.
Okay, and if given time today, do you think you could speak to him about that? He can make a decision about that today rather than setting it off another 30 days?
Possibly, Judge. We have not discussed safety previously, so I would have to take some time to walk him through what that means,
Sure.
the consequences of that, and if he's unsuccessful, the results of that would be on him upon revocation.
Okay, well, how about this? How about I'll let you conclude your other cases, and then if you need to come over here for the contested hearing, we can have Mr. Racco come as well. And that way, we have some time where you can visit with him this afternoon so he can make that decision. Will that be
Yes.
okay?
Yes, Judge.
Okay.
And Judge, what I'll do is I'll visit with him before I head over there, and if it looks like we've reached an agreement, I'll ask that he be transported. Otherwise, if I can just get a reset date, then we'll go forward on the contested hearing.
Okay.
Last one I have, Judge, is Mr. Murph, Colton Murph.
Mr. Murph, if you'll come forward, sir. CR 2060.
And Judge, just a clarification, real quick on Mr. Racco's case. I misspoke. The offer was not to continue him on deferred, but actually he would be adjudicated and placed on straight probation with that additional condition put in place. So I just want to make sure the record was clear on that.
Okay, thank you, Mr. Manning. I appreciate that.
No problem. Judge, I was assigned Mr. Murph's case 7 days ago, and so we are unable to be prepared for a contested hearing on today's docket. I requested I requested a reset, and the state did not oppose that, and so we request that we reset on the contested docket for September 29th. Additionally, I've also received an offer on Mr. Murph's case, and I would like to have opportunity to talk to him about that as well.
All right, court grants your motion, sets Mr. Murph's motion to be heard on September 29th at 1:30.
Just like that.
Yeah, we're three Thursday and Friday, and this is one. Wednesday. You come in, I can stay.
Yeah.
All right, Mr. Schmidt, are you ready?
Yes, sir. I've got Skylar Tanner here.
All right, Skylar Tanner, CR 2312. Go ahead. Mr.
I plead judge, and ultimately on the state's motion, Mr. Tanner intends to plead true for a recommendation of that he be revoked and sentenced to 6 years in the Texas Department of Criminal Justice Institution Division. The order to pay the balance of his financial obligations, which are $1,500 in fines, $85.20 in court costs. He's got 87 days credit towards that sentence.
All right, thank you, Mr. Schmidt. I'm gonna pull up his motion real quick.
Judge, we have received and reviewed a copy of the state's motion. So in these proceedings, we wait formal reading of that.
All right, thank you, Mr. Schmidt.
Yes, sir.
All right, Mr. Tanner, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, Mr. Tanner. You can lower your hand. All right, Mr. Tanner. Mr. Tanner, it appears that you appeared before the court on May 25th of 2021. Pled guilty to unlawful possession of a firearm by a felon, a third-degree felony. The court reviewed the evidence, heard your plea agreement, followed the plea agreement, assessed your punishment at 10 years confinement, and the Texas Department of Criminal Justice ordered you to pay a fine, but suspended that sentence, placed you on community supervision for 5 years. And it was during that period of your community supervision that the state has filed its motion to revoke your community supervision and has alleged in 9 separate counts various ways that you have violated the terms of your community supervision. Do you feel like you've had enough time to discuss this state's motion to revoke with your attorney, Mr. Schmidt?
Yes, sir.
Okay, and are you happy with Mr. Schmidt as your lawyer?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you don't understand?
No, sir.
Okay, and so court notes that Mr. Tanner has waived the formal reading of the state's motion to revoke. So at this time, Mr. Tanner, are the counts or are the counts 1 through 9 in that state's motion, are those counts true or not true?
Yes, sir, true.
And are you pleading true to each one of those counts because what's alleged is in fact true?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead true today?
No, sir.
Mr. Manning, I'm sorry, Mr. Schmidt, you believe Mr. Tanner to be competent today?
I do.
All right. Court hereby accepts Skylar Tanner's plea of true to each count as alleged in the state's motion to revoke. Any objection to the admission of the defendant's waiver of rights and plea of true?
No objection.
All right, that is admitted and the court takes judicial notice of Mr. Tanner's judicial confession. Anything further from the state?
No, Your Honor, read this.
Anything further from the defense, Mr. Schmidt?
Nothing further, Judge.
All right, then based on the evidence in Mr. Tanner's judicial confession, the court finds that each count alleged is true. The court hereby upon that finding revokes Mr. Tanner's community supervision, assesses his punishment at 6 years confinement in TDC, orders him to pay the balance of his financial obligations, and awards him 87 days credit towards this sentence for the time that he has spent in jail on this cause. Mr. Tanner, you hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm gonna have you step over the deputy to be fingerprinted. Good luck to you, sir. Who do you like next, Mr. Schmidt?
Jerry Powell.
Gerald Powell, CR 21235. All right, what's our announcement on Mr. Powell today?
Judge, the announcement is as follows. The Dr. Proctor has contacted Tom DeCurry and myself, I believe it was earlier in the week. He's got a little bit more work to do on Mr. Powell as far as his evaluation is concerned. And once again, we're asking to carry my motion to quash pending the results. In addition to that, I have, as the court is aware, requested funds on Mr. Powell's behalf, which I'm in the process of retaining an expert as well. So for today's purposes, we'd ask that it be either carried to a status setting whenever the court would like. But I think the state, Ms. Curry and myself are in agreement to pass on the motion to quash as of today.
And did Dr. Proctor indicate when he expects to be through?
Judge, I'd be lying to you if I could quote a date. I'd have to pull that email. If you want to bear with me, I can.
And do you know about, yeah, if you don't mind pulling that up, and then if you'll tell me about how much time you think you need on your motion to quash.
Judge, I think that first, Dr. Proctor, he contacted us August 19th and stated that he was waiting on some more records. And once he got those, he'd swing over and finish up the evaluation. That was the last update I got from Dr. Proctor. But he made it sound like it was, sooner rather than later, as ironic as that sounds in this case. And as far as the motion to quash is concerned, it is a high likelihood that after speaking with Ms. Curry, that matter may be submitted by brief to the court. In other words, I don't think that I'm not certain that evidence needs to be taken on the motion to quash. But in the event that the court wanted the hearing, it shouldn't take more than an hour, I would imagine.
All right, let's just carry it to the September evidentiary docket, September 29th at 1:30. And then if there's no request, then we'll just submit by brief and the court can take it up.
Yes, sir.
All right, you ready on Mr. Campbell?
I am, Judge.
All right, Robert Campbell, CR 19-108. Motion to adjudicate.
That's correct, Judge. So ultimately, Judge, I kind of anticipated having a resolution for the court today. And I came and met with Mr. Campbell early, and he had relayed some things to me pertaining to his prior counsel that concern me significantly. I think that at this point, what I'm going to anticipate doing is seeking permission from the court via motion to revisit the initial plea. Obviously, the vehicle for that is maybe complex, and at this point in time, what we would like to do, and I spoke with Ms. Heisel about it, is to investigate the ability or the possibility of perhaps giving Mr. Campbell an opportunity to revisit the plea. There are, in my estimation, once I get the motion for the court, there's a likelihood that there would be some evidence that the court would want to hear pertaining to the initial plea and prior counsel. But as of today, what I'm asking the court to do is to reset Mr. Campbell so that we can figure out the correct vehicle to do that.
How much time do you need, Mr. Schmidt?
Judge, and I understand the court is probably wanting to rush us, and I know Mr. Campbell wants to get this done as well. Ultimately, I think that the initial filings, we could get those done probably within the next couple of weeks, and perhaps have a hearing on that issue on that next, whatever that docket date is, in September.
Okay. Court will carry the motion to adjudicate to 9/29 at 1:30.
There Benson Franny. I got Benson Franny, 07152.
All right. Court has reviewed Mr. Freeney's request for court-appointed counsel. Mr. Freeney, although I think the information is seriously deficient on what you put you had no money, no assets, no nothing, yet you're still alive. So I find that hard to believe, but regardless, I've appointed the Honorable Richard Schmidt to represent you. And I'm going to reset this to September 29th at 1:30 for the hearing on Mr. Freeney's motion to revoke. Is Mr. Strada there? It'd be the same announcement, I'm sure, right?
Yes, sir, it is.
All right, this is cause number CR 240, State versus Matthew Estrada. Court has appointed the Honorable Richard Schmidt to represent Mr. Estrada based on finding of indigency. The court hereby sets this motion to revoke on September 29th at 1:30 to give counsel time to prepare for the case. All right, Mr. Schmidt, who we have left? Ronald Toll.
Honestly, yes, sir.
Mr. Toll, if you'll come on up, sir. This is Mr. Toll's motion to revoke CR 21-146.
That's correct, Judge. I've spoken with Mr. Woodwike, and it appears as though the DA's office has indicted the higher felony case that's been the holdup on Mr. Toll's business here. And I suspect that I'll have received the discovery on the new indicted case. I don't have that cause number yet. But we'll be asked to pass the motion and the state's motion and carry it with the indicted higher felony case.
All right, I'm not sure. I think that was just returned from the grand jury because I don't see it in the system.
Yeah, it was Friday, Judge.
All right, I'm not sure when Ms. Taborham's going to set that.
CR 22, for the court record in CR 22-00297. The number of the new case. We don't have any information.
All right, and what's the name of that charge? Second or first? Second. All right, so I'm gonna go ahead and try to set, I'm just gonna go ahead and set that for arraignment today. I'm not sure if Ms. Taborham's already set that or what she was anticipating, but I'm gonna set that for arraignment. You remind me, Mr. Schmidt, are you available on September 27th?
Yes, sir, September 27th.
Okay, if I had the indictment, it's not in the clerk's file, so I don't have the indictment. Otherwise, we do the arraignment today, but that'll give you time. You'll make sure that Mr. Schmidt has access to the discovery on that, or we'll be appointing him to represent Mr. Toll.
We don't have a stamp copy back yet, but we'll make sure.
And Judge, could I get that cause number on the new indictment? I
Yes,
didn't get it.
CR 22-00297.
Thank you.
All right, we'll set each one. We'll set this case, the MTA on 9/27, and we'll set the other one for arraignment on 9/27.
I believe that's all I have on your docket this
I
afternoon.
do believe that to be true. Yes, sir.
Thank you, Judge.
Thank you. I appreciate you.
And Judge, if I may, I had chance to speak to Mr. Racco. I believe we're gonna try to go forward with that plea. He'll be transported over to the courthouse if we can get the paperwork began, so I can go over that.
Okay. That's been relayed to the state and they said they're working on it.
Thank you, Judge.
All right, Deputy McLeish, I have Mr. Ashmore on Zoom for his clients. So let me try to bring him in at this time.
Yes, sir. And Your Honor, just so you know, we do have Mr. Hamden in the room, but they're gonna have to go find Mr. Spriggs. So he may or may not make it by the time we're done with Mr. Hamden.
You say Mr. Spriggs may or may not make it?
He may not make it by the time we're done with Mr. Hamden, but if he doesn't, it should be just a moment before he is here.
I think I've lost Mr. Ashmore too. He's not logged in anymore. So just have Mr. Hamden have a seat and I got to chase Mr. Ashmore down.
Yes, sir.
I didn't know when we were there.
She was supposed to play and she did not.
Okay.
Yeah.
Just so you know, I am also going to report this afternoon, so I can take paper or take papers.
Hello, friend.
Hello, friend, back to you. Where are you this afternoon?
We've got a speaker coming into the office for some professional development CLE stuff, and
Gotcha.
I'm unable to make it to Van Zant, to the Free State, unfortunately. Thank you for accommodating me.
Hey, you need all the professional development training you can get your hands on.
You know I do. You know,
So you're over in Rockwall?
I'm in the Rock. I just left Terrell about an hour ago. I'm back here. I got to do a few things, and then I'll be training.
Gotcha.
Is that a still shot of Tyler and Hillary playing Brick Breaker? Oh, they got I'm not muted over there. Whoops. They probably don't even remember what Brick Breaker is.
I don't know what Brick Breaker is.
It was like the first game you could get on a smartphone. It was back when they had Blackberries.
Bejeweled. Do what? Bejeweled. Bejeweled? Yeah. Like Bejeweled?
Yeah, yeah.
Like with that Candy Crush? Candy Crush? Yeah.
Candy Crush, man. That's the new thing.
All right. Court call CR 1576, State versus Mahar Hamden. This is motion to adjudicate. Mr. Ashmore, I believe you were just appointed as substitute counsel for Mr. Schmidt earlier this
Yes,
month.
Judge.
And I'm
Yes,
assuming.
Judge.
Go ahead.
Sorry. No, I'm sorry. I just got the discovery a day or two ago. I have spoken to my client. I understand that there was some effort to negotiate a resolution that may or may not include reinstatement. And I haven't had time to visit with the state on what that may look like. So if I could get a docket setting and not a contested hearing setting, I'd like to explore that possibility, Judge.
Well, what I would do is I could set it for 9/27 for non-contested, but then I would also set it for 9/29 for contested, so that if on the 27th, y'all don't work it out, we don't waste another month. Or we just set it on 9/29 and it either gets done or we have a hearing.
May I flip the camera off and switch over to the calendar for a moment, Judge?
Please do.
Judge, I'm available on the 27th. I'm actually out of the office at a CLE on the 29th, but just all the motivation to get it done on the 27th.
But what you're telling me is that the next contested docket I could put it on would be the end of October.
Well, is there one at the end of this month? I mean,
You're on it.
oh, this is it. This is the contested setting. Yes, Judge, I would respectfully request to not be on the 29th. I've prepaid for that continuing education, reserve the hotel, those things.
All right, give me just one moment. Let me.
Yes, Judge.
All right, let's do this. Let's set it for a contested hearing on the 27th. That's not the contested hearing date. But in reviewing the state's motion to adjudicate, I think the testimony will probably be pretty brief.
Very well, Judge. I appreciate that very much.
So if there's no agreement by 9/27, we'll take up the motion on that day.
Yes.
All right, Mr. Hamden, we'll see you on September 27th at 1:30. All right, you ready on Mr. Spriggs?
I am, Your Honor.
Is Mr. Spriggs there, Deputy McLeish?
Yes, sir.
All right, this is cause number CR 21-371, State versus Casey Lynn Spriggs. I believe I set this or asked for it to be set anyway.
Mhm.
Mr. Ashmore, what I wanted to do, I think you had filed a motion for funds for an expert, I believe, for the forensic
Yes.
autopsy
Yes.
or expert. And I believe
Len
that
Lenfest.
my recollection is that I asked you to try to work some magic without having to spend any money by contacting the forensic pathologist there in Dallas at Swift's or whoever did that to try to see if we couldn't get the information that you needed for Mr. Spriggs's defense without having to grant that that motion. It's my understanding that you've tried to do that and you've not had success. Is that correct? Can you just update the court on that?
Yeah, absolutely, Judge. One, thank you for the time to do that. We sent some nice letters and then one not so nice letter. And it wasn't discourteous, but one thing that I sure hope I didn't do was get the county judge of Dallas complaining to the county judge of Van Zant County about, hey, look, we can't have our medical examiners, interviewed for free. It costs our county money. And I sure don't want to, I know that's a resource that a lot of counties in North Texas have to have. And so Dr. Lenfest, per the Dallas County Commissioners Court, is entitled to, 100 something or 200, whatever his hourly rate is. I don't think my question and answer session with him will be more than an hour. And I'm asking the court for leave of court, grant that motion, disperse those funds, or allow me to pay him and then submit a bill. I'm good with either scenario, just to speed this up. So one, I don't, unintentionally put these two, county government officials in a fight over just the basic disclosure of information that's relevant material to the state's case and to the defense of Mr. Spriggs. So
Yeah.
that's my respectful request.
And that hasn't happened. There's no tension or anything between Dallas and Van Zandt. There's nothing like that. I just understand that they haven't given you the information that you wanted free of charge, and they are requiring money. So
Right.
The court will grant the request for funds for witness expense. And I believe that, how much did you ask for?
I think it was like an hour
Yeah, $337.50.
rate, which I think is under $400. It might even be under $300. It's not a big ask.
Okay. All right. The court will,
That is my recollection, but I don't. Sorry.
that's fine. That's fine. Court will grant your request, but I need an order. You send a request, but I don't have an
Yes,
order.
Judge.
Authorize that. If you'll submit that order, I'll get that signed. And so you'll be able to go ahead and incur the expense and then bill the county, and the county will reimburse you for that expense.
Perfect. Thank you so much, Judge.
And it looks
We'll
like,
get that to you.
and it looks like we are set today. We're not set past today. So, is there any other, tell me about pre-trial issues. Other than this issue that we've taken care of today, is there anything else regarding the pre-trial discovery, lack thereof, or anything that we need to address before we make the next setting?
I I don't know what the fruits of this interview will bear. So there may be a need for at least, I think we've already got a motion for leave to file additional pretrial motions just because of the nature of this offense. And I think the court has said on the record more than once that will be granted as long as they're timely filed with plenty of notice, and they will be. I'm not exactly sure what Dr. Lenfest what light he will shed on the case, but there may be a need for additional pretrial motions. I know that the state resolved one of the co-defendants matters, I believe Tuesday, and I know that they're going to work on a production of whatever that judgment or anything relevant to that co-defendant may be. I don't have that yet, but I know they're working on getting me that. So my request would be another pretrial setting. I'm going to get you an order and interview Dr. Lenfest as soon as he can see me, even if it's next week, if we can get something lined up next week or the week after, depending on his availability. And we can be back here on September 26th with perhaps the last of any pretrial issues, and then we can set this matter for final docket or what have you.
Okay.
Hopefully.
All right.
Fingers crossed.
Court will set Mr. Spriggs for a pretrial hearing on September 27th, and we'll also take up any status of the Dallas forensic autopsy witness discovery with Dr. Lenfest. So if for some reason, Dr. Lenfest, you can't see him before that time, then you'll just make that announcement on the 27th, and we'll figure it out from there.
Yes, Judge. Thank you so much.
Is there anything else that the court needs to take up for Mr. Spriggs today?
No, thank you so much, Judge, and thanks for allowing me to appear by Zoom today.
Yes, sir. All right. We appreciate you.
Okay. We'll see y'all soon. Bye-bye.
All right, Mr. Spriggs, we'll see you on 9/27.
Thanks, sir.
All right. Is that everyone at the jail?
It is, Your Honor.
Thank you, ma'am. Very much. Appreciate your help.
Absolutely. I would expect transport to be over there fairly shortly. I asked them to go ahead and get moving a little while ago, so
Thank you so much. I do appreciate that.
thank you, sir.
Right. So we don't have anyone here until they get here, right? We don't have anyone else.
I don't know if they can take it now, after it's later. Chambers. I'll run it with some issues.
Okay.
Must be cool.
Maybe.
Oh, is your ACL?
So, no. We just got all those drying fans and asbestos blowing around up there. All right, court's going to stand in recess until the transport deputies get here for our final hearings. All right, we are back on the record and are we ready on anyone?
Yes, Judge, we're ready to reset Mr. Ryder.
All right, Mr. Ragland, just where you're at is fine. This is cause number CR 21-185 state versus Mitchell Wade Ragland. Court will reset Mr. Ragland's motion to revoke to 9:29 at 1:30. And I'll look to hear from council between now and then.
Yes, Judge.
Any luck, Patty? 4:15. All right, Mr. Manning, I believe that Mr. Hernandez needs an interpreter.
Yes, that's correct.
And so Ms. Tabraham has set that up for us with OCA at 4:15.
Okay.
So about 25, 30 minutes.
And Judge, what do you propose for Mr. Rocco, and we step into this moment from
Sure.
Okay.
Absolutely. All right, so I'm just. Are you ready on Mr. Hernandez? If she could get it moved up sooner?
Absolutely, Judge.
Okay. Yeah, let her check. Good afternoon, Mr. Prowse.
Good afternoon, Judge. How are you?
Hey, I'm doing fine. Mr. Manning, attorney for Mr. Reyes is not quite ready. However, we could use this time to do our testing for Mr. Reyes there and let me see. I'm sorry, not Mr. Reyes, Mr. Hernandez. Mark
Sure.
Hernandez. And so if you want to give me a second, let me flip over and I'll get this interpretation going. And then if you'll make sure he's on the Spanish channel, Mr. Abraham, I can let you speak to him and you don't see it. Still nothing? Yeah, I don't know why. Mr. Perales, are you seeing the interpretation functionality on your side? Yeah, I'm in the English channel. I can hear you. This Tabor, what I'm going to do is I'm going to move you back to the waiting room and bring you back in. Maybe it'll reset. I'm not sure. Let's give that a shot. Is the screen maximized to where it's not it's not hiding at the bottom?
Seen that outside, like down there on the right hand corner. But the world's not there.
Are we signed in on the app or are we signed in on the PC or signed on the web?
Oh, here it is, on this one.
Yeah, that's what it appears to be. We'll just switch them out. Close your eyes. You may get motion sickness, Mr. Hey, when you said you were in the Spanish channel, I thought maybe I had just gotten fluent real quick. I was about to update my resume. Okay, I'm gonna go ahead and swear you in, Mr. Perales, and then when Mr. Manning gets here, we'll be ready to go. If you'll raise your right hand. Sir, do you swear that you will make a true translation of the statements of court, the statements and questions of court and counsel to the best of your skill and ability, so help you God? And can you identify yourself and your license number for the record? And Leonard, let me say thank you for being available for us on such short notice. Is he where he can take a break? All right, I believe Mr. Manning's on his way. Let me change this name. Can we interrupt to do this one?
Absolutely.
Just because Mr. Perales is here, he's ready. We sworn him in and I know you're being pulled at all ends, and so sorry to do that. All right, this is writ number WR 2271. Mark Hernandez, is this a writ for it's like personal cognizance bond?
17-151.
Okay, go ahead, Mr. Manning.
Judge, if we can just note for the record, my client has been in jail since, I'm sorry, continuous custody since 4/15/22. Actually, we'd like to simply the facts we're making the bond.
Are you asking me to stipulate the facts? And the problem we're having, Mr. Perales, and I forgot to talk to counsel about is we had damage in our courtroom, so we're not in our normal courtroom. Therefore, we don't have use of microphones that tie directly into the system. So counsel, you either got to talk really loud or you're going to have to come up here and speak closer to this microphone.
I believe we can reach a stipulation that Mr. Hernandez has been in continuous custody since April 15th/2022. And he was arrested on a criminal trespass of habitation with a bond set at $5,000. As I said, he's been in continuous custody. However, it looks like the state added the charge of burglary habitation, intent of a felony on 8/2/22, and I don't know if you say we want to stipulate, but those facts arose out of the same transaction or occurrence as the original arrest, and involved same alleged victims, same date, time, location. As the original trespass application.
Your Honor, the state would stipulate to those facts and dates and timelines. I believe ultimately, Mr. Manning and I just have a different legal argument on this. So I'll defer to the board on how we want to proceed.
What's the issue?
Judge, under 17-151, I believe my client is entitled to a PR bond, or if I need to, I call a witness that's a financial ability to make a bond. He's been in custody over 90 days, was stipulated by the state. And just because the state chose to change the charge or how the charge does not reset the clock on their behalf as a matter of equity, they have 9 days to prepare for a trial. They have the facts they have, and if they choose not to file an indictment or some other charge that arose out of that arrest within the timeline given by the statute, by the courts, then they have to be entitled to be with the law, is under 17-151.
So what was Mr. Hernandez originally arrested for? Criminal trespass of habitation?
Yes, Your Honor.
Okay, and then the burglary of habitation also arrested for that as well?
Your Honor, no, and that's, I think, where our split goes. I'm gonna ask Mr. Manning before I get into any of the facts of the document that I would like to offer evidence. I would give him an opportunity to object and he's going to. To make this fail long, but I didn't give him notice that I was going to be offering.
And Judge, I believe this does match what I previously reviewed. If there was one thing that just need to check while we're here.
So Judge, the state would offer state exhibit 1 for the limited purpose of this hearing, which is the arrest warrant and affidavit on the new charge of burglary of a habitation. So I would offer that at the time.
Judge, I understand. I don't believe it's relevant, objection with relevance, but I understand why the offering it for limited purposes, we object to its relevance on this one.
And do you want to tell me why it's relevant, just to?
Yes, Your Honor, This arrest warrant was issued on A2, which was also served on Mr. Hernandez in the jail. It's the state position that A2 is, if you'll, read the affidavit, you will see that new information came to light that justified, probable cause for a felony charge as opposed to a misdemeanor one. And that, when that information came to light, that additional information is when the arrest warrant was sought for the felony and served on Mr. Hernandez. So it's the state's position that he's only been in since A2 on the facts that support the felony charge. And so the state's position is that the 90 days should start counting there. So I think ultimately we have a disagreement about the reading and interpretation of 151 and not necessarily an issue that requires testimony from Mr. Hernandez.
All right, the court will admit the state's evidence for the limited purposes of this writ hearing. So what is the disagreement as to 17-151? What's the state's position?
The state's position is that new information arose that changed the probable cause for the charge. And therefore that the 90 days should have started counting on that charge on A2 when the new information arose.
Okay, and Mr. Manning?
Judge, under Ex parte Smith and Ex parte Gill, both those cases talk about how no matter what the seriousness of the offense or the situation, whether it's murder or whether it's some other serious offense, a person who's detained in trial, detained in jail, pending trial of an accusation must be released on personal bond or the reducing of bond required if the state's not ready for trial of a criminal action within the 90 days of the commencement. This article preserves presumption of innocence by ensuring that an accused, as yet untried and unreleased on bond, will not suffer incidental punitive effects of incarceration during any further delay intended to prosecutorial exercise. Judge, as I said at the beginning of our opening statements, the state had all the witnesses, all the crime scenes, all the dates, times they needed in order to gather this information, and they chose not to. The defense doesn't know why they chose not to, but they chose not to. And so now, 90+ days forward, they're trying to come back and say, oh, wait, we have new information. No, judge, they have all the information they had when he was arrested on 4/15. They just haven't chose to do anything with that until this point in time.
So does the state disagree with Mr. Manning that it had all the information? You said that if the court were to review this, that this develops new information that constitutes a new felony charge that constituted a new arrest?
Yes, Your Honor, the state will stipulate that all of this arose out of the same facts, circumstances, and timeline. However, there were some witness interviews that were not conducted until a later date, that the result of those witness interviews was probable cause for a different charge.
Okay, and so Mr. Manning, I would like for you to go ahead and call your client to go over the other factors of bail. And so Mr. Hernandez, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you may lower your hand. Go ahead, Mr. Manning.
Mr. Hernandez, where do you reside? Where do you reside, Mr. Hernandez?
It'll still make it louder to go here.
¿Me ha podido sacar la dirección de donde vivo? Está en mi teléfono, no me han dejado preguntarlo para sacar el número de teléfono.
That's all right. How long have you lived here in Van Zandt County?
Solamente llevo como Yo tenía 2 meses que llegué aquí y ahorita llevo 4 encerrados, 4 como 6 meses.
And were you working before you were detained?
Estaba trabajando ahí en el gobierno.
Did you have any vehicles or property that you own?
No,
Do you have any bank accounts or stocks or anything that you could sell in order to make a bond in this case?
no,
Is it safe to say you were living paycheck to paycheck in order to cover expenses?
sí,
What type of work were you doing?
cuidando ganado.
And how were you? Thank you. How were you paid for your work as handling cattle?
Me pagaban en efectivo,
Okay, and how much would you make per week?
me pagaban $600.
And what expenses did you have?
Para renta, mandar a mi familia. A mandar.
And at the end of the month, would you have any of that money left over? Is it true that you also filed an application where you had an affidavit for your indigency status that was approved by this court?
Sí,
And did you provide a truthful recounting or picture of what your resources were on that application for a court appointed attorney? Your Honor, I asked the court to take judicial notice that it's filed, particularly the affidavit that was filed and granted in terms of his indigent status here in this court and appointment of counsel, and I passed the notice.
Court will take notice that Mr. Hernandez has been found indigent for the purposes of appointed counsel. Faisal? Mr. Hernandez, can you tell me if you are released where you will reside?
un amigo. En mi teléfono. Un amigo que vive en un pueblo de cerca, pero la dirección de él la tengo en mi teléfono.
Do you know what town or what county?
Cerca de Taylor,
Close to Tatum? Is that,
cerca de Taylor. Taylor.
say it out loud, I don't read lips.
I think he's saying.
Tyler? Is it Tyler, Texas, Smith County?
Taylor. No.
Okay. Okay. And will, does he have a job waiting for him if he were to be released?
Estamos esperándome, la verdad, no. Tengo 4 meses aquí.
Okay, all right. Thank you, Mr. Hernandez. All right, is there anything further from the defense? Mr. Manning?
Judge, I did have one more clarification. I'm not sure. On Mr. Hernandez's jail screen, I don't show that the bond is set. There hasn't been a bond set, if we can. Depending on what the court's findings are, if we can make a finding on. I didn't file that motion. We request one, so if the court wants to be able to.
And is that the bond on the Class A or the criminal trespass habitation? Or,
That's what they.
okay, I see that there's a Judge Winters recommended $100,000 bond on the warrant here. But that doesn't mean that it's been set, it's just recommended. And I don't have the magistration paperwork to show what the magistrate set the bail as. Okay. Okay, all right, then the court, anything further from the state? Nothing further, Mr. Manning? Okay, all right, the court's going to take the arguments of counsel and the evidence into consideration, and I will issue a ruling at the end of court today. And I will notify the parties of the court's ruling. Does Mr. Hernandez have any questions of counsel or of the court, Mr. Morales?
Ya ver si me daba permiso de sacar uno del teléfono. Es porque me dijeron que necesitaba un registro del juez, para sacar el número de teléfono.
You can let Mr. Hernandez know that I believe that is up to the sheriff's office and their policy on him accessing his property. However, I will inquire with the sheriff's office staff, and if they do require a court order to allow him to access his phone for purposes of communicating with his family or loved ones, then I'll assist him with that. And I'm going to ask the Honorable Deputy Erin McLeish if she will help me inquire into the jail staff about that. I don't believe it's going to require court order intervention. Anything else, Mr. Hernandez? All right. All right. If there's nothing further, then we'll be adjourned in this hearing. Thank you, Mr. Manning. Sorry for interrupting. Thank you, Mr. Morales, again, on such short notice. You too. We'll see you soon. On what?
You learned that trick from. Should we mention this or?
Probably the cheer trial too. posted on the web.
That's right. Posted Friday at 4:59. All right, Mr. Rockwell. You can just stand where you are. All right, this is cause numbers CR 2189 and and 2020-596, State of Texas versus Cannon Nash Rackow. Mr. Rackow, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, lower your hand. Make sure you speak up loudly and clearly so I can hear you, so my court reporter can take down what you have to say. Mr. Rackow, you were before the court previously on each one of these cases on August 12th of 2021 in cause number CR 2189. You were before the court on a driving while intoxicated Class B misdemeanor. The court heard the evidence, found that there was enough evidence to convict you. However, the court deferred a finding of guilt and placed you on community supervision for 18 months. Court also ordered you to pay a $100 fine. You were also before the court, I believe, on that same day for a Class A misdemeanor offense of assault causes bodily injury, family member. The court heard the evidence, found there was enough evidence to convict you. However, the court deferred a finding of guilt and also placed you on deferred community supervision for 18 months with a $100 fine in that case as well. During this period of community supervision, the state has filed its motion to adjudicate and revoke your community supervision. And in each motion, they have alleged in your driving while intoxicated motion, they have alleged in 8 counts, various ways that you have violated your community supervision. In the assault family member case, they have alleged 5 counts. Have you had enough time to speak with your attorney, Mr. Manning, regarding both of these cases? And you feel like you had enough time to talk with him about these cases, have all of your legal questions answered? Is there anything about the paperwork that you've read over and signed today that you do not understand? Mr. Manning, do you believe your client to be competent today? And does he waive the formal reading of the motion to adjudicate in each case? And is it his intent to plead true to all counts in both motions?
Right.
Okay.
Great controversy, judge, there's only 2 hearings on the docket, but there is a 2020 cause number that was transferred up to this board. So you should have, believe 8, 9, and 9, 0. So you should also have CR 21-0009 in front of you, which is a 3rd-degree injury to a child.
I don't have that. Oh, hang on, maybe it's over here. Maybe it's on a separate. Okay. All right, and so in cause number C, thank you. In cause number CR 2190, you were charged with injury to a child, a 3rd-degree felony, and on that same date, the court heard the evidence, deferred a finding of guilt, placed you on 3 years community supervision, and ordered you to pay a $3,000 fine. And in that case, during your community supervision, the state alleged in its motion that you violated in 7 separate counts. So for each one of those motions, does your state, does this defendant waive the formal reading of each one of the motions? And it's intentionally true to all counts and all 3 motions. All right, Mr. Rackow, then I'm going to ask you, how do you plead to counts 1 through 8 in cause number CR 2189 on the charge of driving while intoxicated? But it would be true or not true. And as to the counts contained in CR 2190, which is the injury to a child, 3rd-degree felony, as to counts 1 through 7, are those counts true or not true? And on the charge of assault of a family member, 2020-596, as to counts 1 through 5, are those counts true or not true? And Mr. Rackau, are you telling me that all of these counts that you have pled true to are in fact true? You're not just telling me that so you can get a certain plea agreement today, is that right? And Mr. Rackau, has anyone threatened you, forced you, or pressured you to plead true to any of these counts in any of these cases? All right, court will accept Mr. Rackau's plea of true as to each count and each motion. Mr. Manning, is there any objection to the admission of the defendant's waiver of rights and plea of true in each case?
No objection.
Those are admitted. The court will take judicial notice of Mr. Rackau's judicial confession. Anything further from the state? From the defense? All right, and I see here that the plea agreement in CR 2189 is for, upon that plea of true, states recommending that Mr. Rackau his guilt be adjudicated, that he be convicted of driving while intoxicated, that his punishment be assessed at 50 days confinement in the county jail, with him receiving credit for time served and him being ordered to pay the balance of his financial obligations. I see that the plea agreement in the injury to a child case is that upon that plea of true, his guilt be adjudicated, he be sentenced to 4 years confinement in prison, with that sentence being suspended and him being placed on 3 years community supervision and being ordered to pay the balance of his financial obligations. Also, as a condition of community supervision, he's to attend the substance abuse felony punishment facility. And lastly, in 2025-96, on the charge of assault, causes bodily injury of a family member, upon the plea of true, guilt be adjudicated, his community supervision be revoked, his punishment be assessed at 27 days confinement in the Van Zandt County Jail. Balance of his financial obligations. This week can get any weirder, it will. With 27 days credit for time served. Are those the plea agreements you want me to approve, Mr. Rackau? And if I put you back on probation and I send you to safety, you're telling me that you will go down there with a positive attitude, that you will seek help for your drug addiction, and then you'll come back and be compliant on community supervision? What happens if you don't? For how long? 4 years. All right. Then the court will accept all plea agreements, and the court will follow the plea agreements, and the court will assess the sentence in the plea agreement and as reflected in the judgment.
Judge, if I may, here, but I believe also part of it was that the unfiled possession case will be taken into consideration. So that was the pronouncement.
That is our agreement, Your Honor, and there was a disposition sheet somewhere in the host three stack of plea paperwork, reflecting that. Oh.
And it's on the judgment for the role.
See any 1245s in any of the plea bargains?
It was on one that, oh, you know what, it went on the bit.
Your Honor, that, if Mr. Manning is comfortable with that, that is our agreement. We do have a disposition sheet, that we sent to the sheriff's office. We can get Mr. Manning a copy back to the record. If everybody's comfortable with it, not formal be on.
And I'm fine with that, so it was part of CO 2189. The condition was start the terms of the agreement that will give to us. Not made it to the correct copy.
I noticed that this plea paperwork has Judge Winter's court identification and his name in there. Has this case been transferred to the 294?
Your Honor, having told me that it had been, I want to forward that. So it was filed down in the treasurer's court and then wherever it was filed, but my understanding is that there was a complete transfer.
And then I delivered to Mr. Rocco on the original part, that was my condition as well, and it's going to be submitted on one bill for.
Well, I just want to make sure that I have jurisdiction to adjudicate his guilt.
My understanding is.
Okay. All right, Mr. Raquel. Mr. Raquel, I'm gonna put the ball back in your court. Okay? You've already dribbled it out of bounds one time. I wouldn't dribble out of bounds again. I'm not gonna give you the ball again. You understand what I'm telling you? All right, I want you to come on up here and be fingerprinted with Deputy McLeish. All right, if there's nothing further, then we'll be adjourned for the day. Okay, Brian, will you give this to Deputy McLeish? There's another one that needs to be fingerprinted.